2 minutes on.
Okay, you're all right. If you need me, just send me an email and I'll be up.
You're not supposed to signature. Can you just knock on the door so I don't need you?
Coming in here.
Court rise. Appeal in a matter of Libyan Investment Authority and others, and King and others.
Disagree, Mr. Onslow. Sorry for the slight delay.
May it please your lordship, I appear with Miss Tandy for the appellants, and my learned friend Onslow appears with Miss Holderness for the respondents. The court will be aware that the appeal concerns a very narrow issue, ground 7 upon which permission was granted, and the central features of the appeal are twofold. The words already in issue, which appear in section 35 of the Limitation Act and do not appear in Rule 17.4, and the particular factual situation of no extant particulars of claim. And there are two facets to that which are apparent on the face of the decision of the judge below. The first is, of course, that factually there are no particulars of claim. But the second is of some significance, which is that this is not a Chengiz situation where the particulars of claim have been struck out for prolixity and the party's been ordered to replead them in an acceptable manner in accordance with the rules. This is a case, and we respectfully submit, materially different case, where what has happened is the judge has in fact dismissed the claims on summary judgment, which is a substantive disposition of the issues that were before him, not merely procedurally striking out a prolix.
So you would accept that the correct analysis of his October 2018 judgment was that it was a judgment granting summary judgment, not a striking out.
Well, he did both, in fact. He granted...
Not if you look at the text of the judgment itself, because he's very clear. He says in paragraph 40 he's going to give permission to re-amend the particulars of claim, not striking them out. And he says the question of whether real prospects of success is a different one. And then all the downstream analysis in the judgment is about real prospect of success. So it's all about summary judgment.
Well, I'm not sure that's quite right with respect. What happened was there were... he was concerned with whether or not the application was to strike out and or for summary judgment, and he granted it.
He granted summary judgment on the analysis in the judgment.
And ordered that the particulars claim be struck out because they disclosed no cause of action.
No, well,
because having dismissed the claims,
I mean,
there was no
this is
basis
the
on which they could go
confusion
forward.
that's the root of this case, isn't it? Because, as he rightly said in the October 2018 judgment, striking out, you have to assume the facts pleaded true. Evidence is inadmissible, and you ask yourself, on the basis of the assumed facts as pleaded, not looking at the evidence, does it make out a cause of action? Summary judgment is completely the other way around. You look at the evidence and you ask yourself, is there a real prospect of success? And all the analysis in the October 2018 judgment is on no real prospect of success. It's not on whether there's a pleaded cause of action.
Well, it's not. Your Lordship is quite right that it's not on whether there is a pleaded cause of action. That's quite correct. But in fact, what he was doing was a two-part analysis. One was of the factual assertions which underpinned the case. Was there a real prospect of success? And in the light of that, could the causes of action pleaded as a matter of law succeed? So in fact, it was a hybrid of the two in that sense.
Show me any paragraph in the judgment which looks at it in terms of true striking out test instead of the summary judgment test. Because as I see it at the moment, it's all about summary judgment. And just by way of example, paragraph 119, this is page 179 in the core bundle. He says, the case against King Sturge based on deceit, falsity, dishonest intention, state of mind is, in my view, far-fetched. In other words, it's unrealistic. So he's applying the no real prospect of success test. He's not saying that it's strikeable because it doesn't plead a cause of action.
But no, I'm not saying it's strikeable because it doesn't plead a cause of action, doesn't disclose a cause of action. What he was concerned with was, in my respectful submission, Your Lordship's absolutely right that the focus was on the total unreality of their claim. And that's
summary judgment test.
Quite right. But he was also addressed on the issue of whether this pleading could work and could succeed as a matter of law.
What he says, what he says at paragraph 41 of his judgment on page 150 is that you can strike out a claim if it has no reasonable, if satisfied that it's bound to fail.
Precisely.
And that's what he thought. Is that right as a matter of law? Does CPR 3.4 apply if you're satisfied there's no reasonable prospect of success?
Well, it's actually disclosed no reasonable grounds for bringing the claim.
And can you do that by analysing the factual basis of the claim, as you can on a summary judgment application?
Well, my lord, that's why everybody, day in, day out, up and down the country, twins the applications together.
Yes.
For that very reason, because what you don't want to get is summary judgment and the case limping on. Now, it's perfectly open to the court to make one order but not the other.
Yes.
But the court certainly has a jurisdiction. The judge, in his judgment, makes it very clear that that's what he's intending to do, to strike it out. And it's correct that the immediate focus underpinning everything is the complete unreality of the allegations themselves. But he also considers how these deceit claims are actually going to work. And whether, for example, so just so your lordships understand, my clients, the appellants, applied to strike out, and King Sturge didn't.
No, they rode out on the back.
They just sat back and
yes.
swanned up the river on their own, as it were, and then took the benefit of the judgment. But my clients applied to strike out the claim against them on the basis that if on analysis, on a summary judgment footing, the claim against King Sturge couldn't work on the facts, as my Lord Justice Arnold points out, then as a matter of law, it couldn't possibly work against us.
Because you would be charged with conspiracy to deceive.
The claim against us was a dependent claim in law,
yes.
and therefore one as a matter of law, which, after you've made the summary judgment decision, must follow, if we're right on the law, that it discloses no cause of action once the unlawful means have evaporated. So, and it's certainly within the power of the court to make that order. So, I mean, I completely take my Lord Justice Arnold's point that a lot of the argument was about the complete unreality of the deceit claim and the facts and the lack of reliance, lack of falsity, and so forth, which he summarises, we can see on page 179. Para 119, he says, the case against King Sturge, based on deceit, falsity, dishonest intention, and state of mind, is in my view far, far unrealistic. But getting our claim struck out was a question of law. So he was right in our respect.
But that's not actually what he says in 122, is he? He doesn't say this is bad in law. What he says is it doesn't plead a case having a real prospect of success. So again, in the summary judgment test, he's saying, as presently formulated, no real prospect of success, therefore summary judgment. And then he says, but it might be reformulated to give a prospect of success.
Well, my lord, at the end of 122, so in 122, he's looking at the position of the second to seventh defendants. He's not looking at the King's Sturge one. And he says at the end of the first sentence of 122, if there's a basis for reformulating the claim against them on the basis that King Sturge was not a knave, I would not be minded to strike out the action against them at this stage. And then, and I'll come to why he thinks this, because it's quite important. He says, for example, in the pleading at the moment, no reference has been made to the project cash flow document, which of course is now relied on in the new case, showing the cost of the site. It is conceivable, from materials which I've been referred, that might form a realistic element of such a claim. For the avoidance of doubt, as presently pleaded, the existing claim does not plead a case having a real prospect of success.
You read that as against the second to seventh defendants?
No, well, no, it's actually both, if your lordship reads it. He goes on to say King Sturge must be dismissed.
Yes.
Is what he says immediately after that.
Right. So the pre-penultimate sentence, there's no case, no pleaded case having a real prospect of success against anybody.
Yes.
The claim against King Sturge is dead in the water. The claim against the second to seventh might proceed further.
Yes. And can I? We've dived into the middle of it. There were some brief preparatory remarks.
Well, let's let you develop those.
Might I just for a moment?
Before we come back to this.
It may help. I'm obviously very happy to be interrupted and assist the court as the court wishes. But the words already an issue and the unusual situation of not having a particular claim, which that is the effect of the order, and that's where we are a couple of years later. So that is the context with summary judgment on the issues that the previous claim gave rise to. Now, that actually puts the respondents between a rock and a hard place to some extent, because what they have to do, and the judge will see in the transcript of before his ruling on the actual order to be made, realise this might be an insuperable hurdle. What they have to do is they have to navigate within the same facts or substantially the same facts already an issue, but not raise judicata. So they have to find the little wafer-thin gap, as it were, between the requirements of Section 35 and the problem that there's been a judgment on the merits dismissing the claims as then formulated. And Lord Justice David Richards, when granting permission, which is at page 261 of the core bundle, at the bottom of page 261, this leaves the second ground, which is that because the existing particulars of claim had been struck out in their entirety, and the claims there pleaded had been dismissed, it was not open to the judge to re amendments. This is based on the meaning and effect of CPR 17.42 when read with section 35.5a of the Limitation Act. On the facts of this case, highly technical, however, it is right that it's to be read as 17.42 is to be read as restricted to a case where the new claim arises out of the same facts or substantially the same facts as are already an issue on the claim. And he referred to the decision in Samba. Now, that's a decision where I think the learned friend appeared before your lordship.
Remember it.
And it was handed down in, I think, March, 2 months before this hearing. But the judge...
Although that particular point wasn't new in Sandbrook, because it goes back to Good and Martin.
My lord, indeed, in fact, may be said to go back a bit further, as I will submit, in fact. What's said there is there's an argument that has real, I suppose, fanciful prospect of success. Respondents submits no legal authority cited to support it. But obviously Samba is such an authority, and there are a lot of others. And that was not accepted. And also it was suggested that the point wasn't argued, wasn't raised below at all.
Well, Samba doesn't deal with what happens when part of the pleading's been struck out.
Your lordship's absolutely right. Your lordship's absolutely
I think that's what Lord Justice David Richards is referring to.
Indeed. In relation to the issue of an extant pleading, I just want to draw your lordship, the court's attention, if I may, very briefly, to the core bundle at 199, which is paragraph 53 of the strikeout judgment. 199, sorry. And at paragraph 53, the judge, in his judgment on strikeout, says, Mr. Onslow QC first addressed a point raised in the defendant's skeleton argument that there were no facts at all presently in issue because the claimant's re-amended particulars of claim were struck out in their entirety. Now, my lords, I respectfully submit that is precisely the point which is now before the court. It is right, and I think possibly from Mr. Adkin, who prepared the skeleton below, skeleton seeking permission to appeal, was very gracious to the judge by saying he wasn't addressed on it, on the arguments. It's true that the separate freestanding dominance of Section 35 didn't loom large, but it's also true that the submission was made that it was the facts were not in issue because there was no extant pleading, which is precisely the point that's before the court now.
Yes, but what the judge says is that he was addressed on the wording of 17.4 rather than the wording of 35.5.
Well, it's right that he was, but there was also Good and Martin before him, referred to as a footnote in the skeleton at 59.2.
Judges don't have to hunt down every authority in a footnote.
No, my lord, no, absolutely not. But the judge knew what the submission was.
Yes.
And so did my learned friend, and it was argued.
But
it's already, no facts presently in issue. That's exactly the point in my respect to submission.
well, the point was before him, but the argument that's now pinned to the terms of Section 35.5 doesn't seem to have been articulated.
Now, my lord, can I just take the court very briefly to the issue of the policy behind Section 35.5? Because my learned friend suggests that in his skeleton argument that what matters is Rule 17.4 and also suggests that we have not made any observations in relation to the relevant policy, and that's his skeleton at 118 of the core bundle at paragraph 24, where he says, so the appellants say nothing about the critical question of the rationale. Could I just ask the court to look at that, because it's quite important, because in our respectful submission, in that paragraph, the tail is wagging the dog in an important respect. So it's page 118. Paragraph 24. And what's said there is the appellants say nothing about the critical question of the rationale for those provisions. And it's made explicit in various cases. And then it says, see also, for example, Good and Martin at 52, that's actually, there isn't a para 52 in Good and Martin. It doesn't matter, but that does come from Good and Martin. It's in BP and Aon, paragraph 53. But you'll see at the end of it a little footnote. And the footnote is to Lloyds, Bank and Rogers, the judgment of Lord Justice Hobhouse, about what the policy of the section is. And that says the policy of the section was that if factual issues were in any event going to be litigated between the parties should be able to rely upon any cause of action which substantially arises from those facts. So what is typically contemplated is extant particulars of claim, which are going ahead to trial, and the party wants to add another way of putting a point which already arises on the facts that are going to be before the court. And my lords, the reason I say that the tail's wagging the dog is because that is a policy, that statement more fairly and more correctly identifies the policy behind the section than the recognised consequence of that, which is what the actual substantive quote is in paragraph 24. It is true that that is a purpose, but it is far from the only purpose. It's true that it's the purpose is to avoid placing defendants in a position where, if the amendment's allowed, he'll be obliged after the expiration of the limitation period to investigate facts and obtain evidence of matters which are completely outside the ambit of, or unrelated to those facts which he could reasonably be assumed to have investigated. The investigation point is definitely an aspect, a private aspect of the policy, and correctly applied, that will definitely be achieved by Section 35.
What do you mean by a private aspect?
Well, my lord, because in steamship, which is the policy point we did make in our appellant skeleton, which is overlooked by a learned friend, with respect, the policy in Steamship Mutual, which is on page 92, is set out by Lord Justice May.
And he says there's a public interest.
Yes, fair to society generally, whose interest is it to see a finite end to litigation. And the nearer one gets to the end of the relevant limitation period, the more important becomes the interest of the public generally to see these disputes disposed of. And of course, there are other dicta generally about how that now looms larger in the CPR era than it did at the time of that decision in 1986. So there are, of course, the private interests of the individual parties, but there is a wider public interest in justice generally, and it being conducted efficiently and proportionately, and with finality. So, going back, if I may, just to the Lloyd's point, the reason I say tail wagging the dog is because the Lord Justice Hobhouse's dictum in Lloyd's is a golden thread running through almost every single authority in the bundle, and is quoted with ipsissima verba, frequently with emphasis on the in any event going to be litigated point. And I'll just identify for the court those authorities in which it is helpful to have the electronic bundle reference to the page. It doesn't take a lot of time, but Lloyds Bank is obviously at tab 6. It's page 154. Good and Martin, it's 1838F, para 34. BP and Aon, it's 558, paragraph 53. Charles Church Developments, it's 1210H, para 29, onwards. 1212G, para 31. 1212H, para 35. And 1215, para 40. And Then Law Society and Shah, which is tab 18 in the bundle. It's 2263H, with the emphasis added on going to be litigated in any event.
What's the paragraph?
It's at 2263H, my lord. I didn't write the paragraph down, but my junior can find it. And then Robertson Gill, quoted with approval in the Supreme Court at 225E to H. And at letter F in paragraph 41, you'll see the same quote from Lord Justice Hobhouse. And then in Fatal and Walbrook, which is tab 20, it's D10A to B, para 38. In Ballinger and Mercer, it's at 3611D, citing Mr. Justice Coleman and BP and Aon. My lord, the paragraph in Shah was paragraph 29.
Thank you.
And then in Blue Tropic, one of my learned friends' authorities, it's at paragraph 48. In MasterCard and Deutsche Bahn, it's at paragraph 40. In Samba, it's on page 8 at paragraph 39. And my Lord Justice Floyd refers to it again on page 13 at paragraph 57, italicising and emphasising the words "in any event going to be litigated." And in One Blackfriars or Hyde and Nygate, it's pages 12 to 13, paragraph 32. And it's the fourth point. It's referring back to my Lord Justice Floyd's decision in Samba, and there's also a reference again to it at 71. So actually, if one's concerned what the dominant policy behind Section 35 is, there is absolutely no doubt that the unbroken thread comes from this dictum in Lord Justice Hobhouse's decision in Lloyd's Bank. And the fact that it is focused on issues which are in any event going to be litigated is much sharper in a case here where, because all the claims have been dismissed and the particulars of the claim have been struck out, that is not going to happen. So in our respectful submission, it is wrong for a learned friend to say that our analysis ignores the policy. That's absolutely wrong. Our submissions are precisely based on the fact that the policy is to allow a latitude on limitation which would otherwise not be afforded to a party.
But if your submission was correct, the judge would have granted summary judgment in favour of your clients in October 2018, and that would have been the end of the story. But he didn't do that. On the contrary, he expressly gave claimants the chance to reformulate. So therefore, there was no judgment putting an end to the case against your clients at that stage.
Well, my lord, what the judge, can I show your lordship how it emerged? Because it will explain why he did what he did. It's very easy to do, and it doesn't take us a moment. It's in the supplementary bundle.
Can I, just before you move on from
Yes.
that policy point,
Yes.
it's not a prerequisite of taking advantage of Section 35.5 and Rule 17.4 that the first claim is going to be litigated, because you can plead a case A, realise it's doomed, amend to plead a case B out of the same facts, and then drop case A, and that's perfectly permissible.
Your lordship's right. Your lordship's, that's absolutely right. And so, but the focus is, the premise of the policy is that these matters are going to be investigated by the court of trial in any event, factually,
Yes.
within this particular compass. And therefore there's no, the policy balance is struck in favour of a relabelling exercise to add other causes of action arising on the same facts. It's perfectly sensible, what one would expect the policy to be. So your lordship's absolutely right. You, of course, can.
And quite frequently do. I mean,
Yeah.
people quite often realise the way they've pleaded their case isn't going to work.
Indeed. Indeed. But my lord, it's a different situation where judgment has been given, summary a substantive judgment's been given, and those issues have been disposed of.
Yes.
And it is, if I may respectfully submit, actually very important to understand how it was that this actually happened. And it is illuminating because what actually took place was that the judgment, although we have a written judgment from the judge on the strikeout, what actually happened was everyone arrived with no idea what was going to happen. It was not circulated in advance, and that led to a number of corrections being requested from the judge, some of which he acceded to. One important one about calculations being materially incorrect, the parties agreed he should delete, but he declined to do so and left something in instead, saying baffling if not materially incorrect. So that's how it happened.
So he read out his judgment orally.
He read it, and then the judgment was typed up afterwards. And so...
How long does that take, as a matter of interest?
The typing up?
No,
or the reading out?
Reading it out.
I wasn't there. Most of the morning, my lord, I think. So the parties were discovering what was happening in real time, as we all used to at the bar, but no complaints, but it's helpful for the court to know. And then what happens is the transcript of the arguments and the ruling, which my learned friend relies on, which we find at 186 behind tab 2 in the supplementary bundle. And the respondents submit that the court should look at this to see what the judge intended and understand his ruling. And I'm perfectly happy to deal with it on that basis. If we look at page 188, your lordships have page 7.
The judge thought that limitation was not an issue.
My lord, yes. So this is within moments of finishing reading out this judgment.
I know you weren't there, Mr. Green. Do you understand that statement that limitation is not an issue?
Yes, because it's explained below. He wrongly thought that the effect of section 32 was that limitation would apply.
But section 32 just postpones the 6
Precisely.
years until you
Yeah.
know or could with reasonable diligence.
Precisely. He was wrong about it. But,
I see.
and so he says, not an issue because it's a dishonesty claim, which is the section 32 point. And he says, so limitation is not there. The whole thing could go, or alternatively, the claimant could have a short period of time. So he hadn't decided fully at this stage. He refers to his element of disquiet at the bottom, which I'll come back to. And then over the page, he is he's concerned. If your lordship looks at the foot of page 10, in practical terms, there are a couple of points on that. One is that it's not really here or there, but the court is doing itself out of a £10,000 issue fee if they start a new action. And our submission is that that does not suggest he had the correct hierarchy of issues in mind about what should be done. That's not going to break the bank of the claimants, and that's against the background that they've got, I think, £1 billion in an account that they can't do much with apart from litigate, which was in evidence before the court. And the second point is I don't really want them to be put in the position, and I don't feel it'd be just put in the position, that they might have to face a could and should have brought it before type application. So the whole action goes, they start a new action, it's an abusive process, an abuse to start a new action. That's a position I want to avoid them based on the disquiet I And of course, you can give an undertaking not to take that point. Well, also, the correct course for the judge to have done was, if that's what he thought, and had been right about limitation, would have been to say, start a new action on Mr. Adkins' client's undertaking not to take the Henderson Henderson point.
But if there wasn't a limitation issue, then there's nothing wrong with what he did. Because you could amend the existing claim, couldn't you? I mean, if you're not in the territory of Section 35.5 and Rule 17.4, none of these problems arise.
Well, I'm not sure that's what he thought was going to happen, because if you look at 190...
Well, just before we go there, Mr. Adkin is perhaps trying to put him right at line 17, isn't he?
Yes.
And there are two reasons why they would want to keep the claim form alive. One is to have the opportunity to seek to relate their evidence back and thereby potentially avoid limitation.
Precisely.
So,
Didn't work.
right.
And then...
Sorry, 190.
Well, my lord, just on 189, just so your lordship to have where it is, there's a point I'll come back to, is the submission made by Mr. Adkin at line 15, this is in the context of being vexed by the same thing. Mr. Adkin's saying, we were entitled to assume in my submission the claim that we were inviting to your lordship to strike out or dismiss on summary judgment was the claim that claimants wanted to bring against us in relation to the matters that are its subject matter. And then he says, refers to the whole repleted case at the bottom, seeks after the fact to avoid the consequences of the lordship's judgment by introducing a claim you've never heard. That's not a fair way, and so forth. So there's argument about that. And then we come over to 190 at internal page 14, and Mr. Adkins says at line 6, the difficulty he has, learned friend Mr. Onslow has, is there's no reference anywhere else in the pleadings to any unlawful act other than the deceit. And that was the deceit by King Sturge in sending the King Sturge letter. And that's what the claim form said, and that's what the claim form was confined to. And the judge says, absolutely, and that may prove an insuperable obstacle. So the judge was leaving, in my respectful submission, leaving available the wafer-thin opportunity to which I referred earlier, which was the opportunity to plead on the same claim form.
The reference there is to the pleadings, not to the claim form.
Well, my lord, yes, and that was. Can I make two points? Your lordship's absolutely right, but what they had before them at the time was the pleadings which are being struck out, and Mr. Adkin refers to that. But in this particular case, you can see that the claim form is confined to that letter too. And I'll show you, lordships, the claim form, two claim forms in a minute. And the judge recognising it's insuperable, and then Mr. Adkin at the foot of 14, in relation to the judicial disquiet, says the way in which I put the application, as your lordship knows, was that it was on the basis that if King Sturge had no case to face, nobody did. So that's my point on the point Lord Justice Arnold and Lord Justice Nugee were asking about earlier. It's on the facts, you can't possibly, well, facts and law, it can't possibly work against King Sturge. But if that's right, then it can't work against anyone as a matter of law, because the claim against us is a dependent claim as a matter of law. And he says there, and your lordship accepted that proposition, and because of that, it was not necessary for me to address the merits of any of the claims against the second to seventh defendants. I did not need to address your lordship on whether Mr. King had been misleading in anything he said in the letter. I did not need to produce any evidence about the circumstances in which the letter, what he said, came into existence. Your lordship was wrong to assume that I accept in any way there's a case against the second to seventh defendants. Judge says, no, absolutely. The problem is, because you did not do, that I do not have any ground to tread on. And that's in relation to his findings about disquiet. Mr. Adkins says, the reason I did not do this is because I didn't need to. And the reason I didn't need to was because I was shooting at the target the claimants presented. That's a further reason in my submission that underscores the undesirability of allowing them to present a different application. And then at the foot of the page, page 16, line 22, Judge Barker, because however it goes forward, it is on a different footing. And then over the page, at 191, page 19, line 16, Malone and Friend says, in relation to the possibility of being...
I do apologise for writing. I wasn't there. My learned friend is not me.
I don't mean Malone and Friend, Mr. Ronson, I mean Mr. Halpin. I'm so sorry. Line 16, Mr. Halpin says, let me assume against myself we're not a high-powered legal team. We are a high-powered legal team. Client ignores our instructions, our recommendation, insists on proceeding. In that event, all they will do is end up with a very large bill of costs. In my submission, not only myself and Hogan Lovell, but also BDO, who are also extremely sophisticated because of the difficulties identifying who the claimants actually are in the action. BDO are involved to supposedly make sure that the action proceeds properly. And then at line 7, Mr. Halpin says on page 20, internal page 20, line 7, disquiet, of course, is not enough by itself. It's a powerful factor. The judicial instinct is a very powerful factor and should not be ignored by technical rules. And in answer to the BDO point on 192 at page 24, line 18, Mr. Adkins says the problem, of course, with that submission is they already have brought a hopeless claim, and that's why we're all here. And then the judge's ruling is on 193. And it's not exactly a ringing endorsement of the likelihood of this being litigated in any event. It's page internal 28, line 14, ruling. It says, rather than strike out the case in its entirety and leave it to the claimants to issue again and start again, if they can identify some case against either or all, I will leave the claim form hanging by a thread in relation to the second and seventh defendants. And then makes basically an unless order. And in argument, there's various analogies drawn with it being on life support and the last gasp and all that sort of thing. So pausing there, that is illuminating. I think, my Lord Justice Arnold's question to me is based on an assumption, an understandable assumption, that the judge in the strikeout decision would have had the correct principles on limitation in mind.
No, it's got nothing to do with limitation. It's about the distinction between striking out and summary judgment.
Well, my Lord, I meant the question where Your Lordship said to me, if wouldn't he just have, if I was right about the law and the policy, wouldn't the judge have struck out either both or neither? And the point is that in my respectful submission, that question might be underpinned by, or I may be wrong about what Your Lordship was thinking, but if a judge is fundamentally mistaken about the impact of limitation on the proceedings, what one would normally expect him to be thinking is rather undermined because he's proceeding on an unsatisfactory footing at that stage. So that's how that first
out
came
he
to
was
be.
corrected in that, because although it's true that he expressed the view at page, where was it? Page 7, that limitation was not in issue, Mr. Adkin was careful to subsequently to correct him on that and to point out that this limitation could be an issue. So by the time he made his ruling, he was aware that limitation could be an issue. There's nothing in the ruling that suggests that he thought by that point in time that limitation was never going to be an issue.
What one can say, my Lord, is that what he'd said should happen in the judgment moments before, because the order is a reflection of what he said should happen in the judgment, as Your Lordship put to to me earlier. What he said should happen in the judgment did not post-date the correction by Mr. Atkin. So his approach in the judgment should fairly be seen by what he appears to have thought was the position prior to being corrected. Well, doesn't know whether that correction by Mr. Atkin landed or not. And I leave that matter open. I can't say it did or didn't. But what we do know is what was foreshadowed in the judgment appears to be on that footing. And that's how that happened. Now, the order that the judge made is the order that he intended to make, which was to strike out the particulars of claim and to give summary judgment. Because that's clearly what he said he was doing repeatedly.
But he didn't. He didn't grant summary judgment against your clients, putting an end to the claim. On the contrary, as he said both in his reserved judgment and in his extempore ruling, he was giving the claimants a chance to reformulate as against your clients. So he wasn't putting an end to the case as against your client.
I didn't say he was putting an end to the case. All I said was that the order that he made was the order he intended to make. And that...
No, it wasn't all you said. You said that he gave summary judgment. Those words don't appear in the order.
But no, what he did was the claims were dismissed. So that's a substantive. In the order it says the claims are dismissed, as well as... So...
Can we look at
it? Core bundle 134.
134, most great. Sorry.
Yes.
And my lord, it is significant that it was on our application.
Yes.
We weren't the passengers in this. So he makes the order at paragraph 2, dismissed against the first, and the claims are struck out, and the claim form struck out. But he makes a different order in relation to the second to 7th. And he says at 3.31, the striking out of the claim form and dismissal of the action shall be stayed pending the determination of such amendment application. And as to what he anticipated...
Strictly speaking, and this point may not lead anywhere, but the stay in 3.31 of the striking out of the claim form, was that correct?
Well,
I mean, the way that I understand this order works is that so far as the 2nd to 7th defendants is concerned, is that the plea at 3.1 says the pleadings struck out and the claims advanced in them are dismissed, but that must be subject to what follows.
indeed.
And then you have, if, unless you do certain things by 4 o'clock on the 13th of November, the claim form is struck out and the action is dismissed without further order. But the implication is if you do, then they're not struck out. And so to stay the striking out, it seems a little odd to me.
Yeah, my lord, I think that is an oddity in the order, I agree. Because in fact what it was an unless order, that unless you do it within 3 weeks. Come up with your new claim within 3 weeks.
But if what you said in, well, perhaps we don't need to explore that, but there is a slight oddity with the way this is constructed.
My Lord, can I just take you back very, very briefly just to the transcript of what the judge said at page 188, internal page 5. Because if we look, this is where he was considering this issue about the what could survive. And it's line 3 on internal page 5 of transcript at 188 in the supplementary bundle. And it's Judge Barker. I don't think there can be any question about the pleading surviving. The only question is whether the claim form itself is also struck out or dismissed at this stage, or whether that's left to breathe life. And if there's no revised version, that dies. Or if there's some life, then some alternative particulars of claim based on or reformulating the old claim, but based on that claim form. And your lordships will have seen that what in fact happens in the supplementary bundle, you have at page 31 the claim form he was talking about, which cannot sustain the present claim.
But you've not got judgment on that basis. And so that's not an issue for this court.
Well, my lord, what we've got is an order striking out the particulars of the claim.
No. You do not have an order granting you judgment striking out the current version of the particulars of claim on the basis that they are outside the original claim form. And the only issue before this court is a jurisdictional issue under Section 35 of the Limitation Act.
Indeed. So on that issue, it's my learned friend who urges the court to give effect to what the judge really meant. It's not my idea, but if we're going to do it, we might actually look at what he says he intended to do. And if your lordship's just even a visual comparison of pages 31 and 91 shows that they're nothing to do with each other. The whole claim form was completely new, and that rather gives the game away. What the judge was permitting them to do was reformulating and we respectfully submit the limit of his jurisdiction, given the decision that he'd taken, was to allow them to reformulate a claim within the four corners of the existing claim form. Not, and that's what he said he was intending to do. So if we're going to go down the route of giving effect to what the judge intended, that's what he said he would do. There's a striking difference between 31 and 93. And the fact that they had to amend the claim form wholesale, ab initio, rather gives the game away. And my lords, we respectfully say, the judge not having in mind the already in issue, the words already in issue from a jurisdictional point of view, in section 35, is what led him in error, in fact, to approach it as he did. Because what you can't do is keep cantilevering out.
But I'm sorry, if this argument were correct, you would not have needed to have 4 days of argument in 2019, because your case would have been very simple. It would have been, they could only proceed within the existing claim form. They couldn't go outside the existing claim form. They've gone outside the existing claim form, end of.
Well, my lord, one doesn't know, unfortunately, when one goes to court, whether the judge is going to agree with you about all points. It'd be much quicker if they did.
But not only was such a case not advanced, so far as we can tell, You certainly didn't get a decision on that basis, still less there is a ground of appeal for which you have permission on that basis.
Well, my lord, I'm not sure that's quite right. Mr. Adkin, I've shown your lordship the passage in the judgment where the judge refers to the problem of there being no extant particulars of claim, which is precisely the point I'm making, and in that context specifically says there are no facts already in issue. So he uses the words in that, the words that are in section 35 and are not in 17.4. He refers to Good and Martin, where the Court of Appeal holds that you have to add those words into the rule to bring them closer to the statute. And the judge says there's nothing in the argument. And my lord, if you want to know why it took 4 days, not 2, my learned friend was still on his feet at midday on day 2, and in the course of argument had been seeking to put forward possible amendments to the way the pleading should be formulated. And then that therefore meant there had to be a new pleading, so a further date was set for the 3rd of June, and a new pleading arrived a few days earlier, and a note on the Friday night before the Monday on the law, which took Mr. Adkin by surprise, and so a further date was then set. So, I wasn't going to get to the being mucked around bit, in the words of Lord Justice Waller, at this stage, but if one's going to talk about 4 days, that's why it happened. So they were in the last chance saloon, hanging by a thread. They had none less order to produce their particulars. They produced particulars in the face of opposition that it just couldn't work. So a fiduciary duty of loyalty to someone who's your negotiating counterparty is not going to work. So instead they did a limited agency pleading with a duty of honesty. So those amendments were to deal with points made by Mr. Adkin and questions from the judge in the middle of an application which is miles past the last chance saloon most people would be in. And that's why it took 4 days, my lord. Firstly, because one didn't know whether or not the no existing facts point would succeed, and secondly, because what actually happened at the hearing.
Well, we can't rewrite history, but
No, of course not. But
it does seem likely that this point was taken up front, effectively as a preliminary objection. It might have shortened things, but...
Well, my lord, I completely accept that. But I just wanted to make it clear the extent to which it was in fact taken.
It was taken.
My lords, the other point, which is if the court were to get to the point where the court identified an error in the perception of the jurisdiction by ignoring the words already in issue, which is what the judge did, and he noted the difference and ignored it. If that is an error, and if we get to the point where the court is stepping back from matters and looking at the position more generally, upon which my learned friends made a number of submissions on the merits, the learned judge fell into serious error, we say, not a complicated error, a very simple one, when he made actual findings in his original judgment adverse to the appellants, which are demonstrably wrong. So not only was he not...
Sorry, how on earth is that within the scope of your permission to appeal?
My lord, what I was pointing out is if the court reaches the position where the court takes the view that the judge misdirected himself in some respect, and therefore the correct test is to look at the issue through the lens of what was already in issue on the facts, and gets to the point where the court is itself exercising the discretion afresh on the basis of the correct test. So if it's not completely dispositive...
Isn't this been already ventilated with Lord Justice David Richards? As I understand it, he made it crystal clear that the result of the appeal will be binary in nature. Either the re-amended particular claims stand or they don't. Because either there's jurisdiction or there isn't.
Well, my lord...
There's no discretion to be exercised afresh, is there?
Well, my lord, if the learned judge misdirected himself as to the scope of the jurisdiction,
Then you win, then.
Well, I submit we do, but if we get to the position where the court doesn't agree with me, I mean...
Then you lose.
Well,
I don't think it's that complicated.
Well, all I would say is that it was extremely unsatisfactory. I hope the court will forgive me for saying it, but it's extremely unsatisfactory to have unfair criticisms. So say the judge said the JV was agreed when it wasn't. He was wrong about that. The judge said that a mistake was made about the name of a company.
Well, we're not going to go into
And all those matters. He actually made findings about it. And later on, in the second judgment, he said he expressed disquiet. It wasn't really right. But I mean, there it is.
We're not going to make any findings about that here.
Well, I'm grateful. It's only because my learned friend has made quite a bit of the merits in his skeleton argument. My lords, in terms of the policy itself, the significance of what was in the original claim form is what was all going to be litigated in any event. And it's perfectly clear that, for example, on the basis of the claim form, the 2007 report by Strutton Parker, on the basis of which HBOS lent £10 million, was never impugned before, and the chance of having a good file from Strutton Parker for the 2007 letter, which now is indirectly relied on, it's completely fanciful. There is no chance of getting that, and that's not something that was within the purview of the case on the claim form as it stood.
Do I understand it to be your submission that we can't look at the defence to see what was in issue?
Well, my lord, I think the position is that where the pleadings have been struck out, there are no matters...
Well, the defence hasn't been struck out.
My lord, no. The defence was responding to a pleading that had been.
So you are submitting that we can't look at the defence?
My lord, that's my primary submission.
Yeah.
And my secondary submission is, if you do, you shouldn't... There are real risks to that, because what you get into a situation is it rewards a party who runs an extravagant and flawed dishonesty case, because you have to plead back to it all and deny, and therefore, even if that is struck out, on the analysis that you then still have regard to the defence, that would still all be an issue. And that's a bizarre outcome.
Because I mean, your point is that once the re-amended particulars of claim have been struck out, the defence must fall away, because it's defence to that claim.
Precisely.
If that claim's gone, there's nothing in issue on that claim, because the claim is gone.
Yes.
That's your point.
It is. And my consequential point was that it would be very bizarre if that weren't right.
Yes.
As well. And that is, so that submission, I respectfully submit, is entirely consistent with the golden thread of policy running from Lloyd's Bank all the way through the authorities, where the driving focus of the policy is allowing a relabelling exercise, as it were, of matters which are going to have to be investigated at trial in any event, or would have to be. I take my Lord Justice Nugee's point that they would have to be, but obviously if you abandon them once you've substituted the other, fair enough. But the point is, you consider the position before the amendment. So before they've abandoned it, they would have to be investigated at trial anyway. So actually, I think there's a distinction without a difference in the end. Our submission is consistent with the policy. It's consistent with the words of the statute, which should not be departed from. The policy I've identified has been approved in the Supreme Court in Roberts and Gill. it's wrong to reformulate the words of the statute by saying things like the approach means you don't have to investigate wholly unrelated issues. Because that is not a substitute for what Parliament has laid down. It may well be a benefit from the application of the policy behind Section 35, but it's not the statute, and it's no substitute for the requirements Parliament has laid down for what should already be an issue. And so on that I would submit that where the judge said, but based on that claim form, he was in that respect right if there is jurisdiction where only the claim form remains to grant permission within the four corners of that claim form. So option 1, no jurisdiction at all. Option 2, jurisdiction but only within the four corners of the claim form. And in my submission, we win on either of those. And the telltale is the fact they had to amend the claim form supplementary bundle, page 31, to supplementary bundle, page 93. They're fundamentally different. And they haven't managed to find that wafer-thin chink of light where they sidestep res judicata and nonetheless bring a claim that can work. In fact, what they do in the pleading is they try to still argue that they wanted a property valuation, but there's no difference between an enterprise valuation and a property valuation. And that's completely contrary to what the judge found. I mean, that's not a point for today, but I'm just illustrating the difficulty that I identified before.
The application to amend was not just to replead the particulars of claim, but to amend the claim form. Re-amend the claim form.
My lord, yes.
Rule 17.4 allows you to amend a claim form.
My lord, yes.
So why couldn't they amend the claim form and then replead? Why does it have to be based on the claim form as it existed? Why can't it be the claim form as it existed or as duly amended?
Well, my lord, your lordship's absolutely right. And still, our submission is the same. There's no suspension of Section 35 of the Limitation Act when you're amending a claim form. Not looser rules for a claim form than there are for the particulars of claim. Section 35 bites on the amendment of the claim form just as much as it does on the particulars. So that's why I say the judge was right when he said, based on that claim form. Because you're outside limitation. If he had jurisdiction at all, it was jurisdiction to allow any relabeling within the four corners of that claim form. Your lordship's right, you can amend the claim form, but as a relabeling exercise internal to that claim form. What you can't do is forget about Section 35, apply a very loose reading, a generous reading of CPR 17.4 to widen the claim form, so then you can go off on a claim on a completely different footing.
So when it came before court in May 2019,
Yes,
there were no particulars of claim because they'd been struck out.
correct.
But there was a claim form.
My lord, yes.
There was an application to amend the claim form. Re-amend, technically.
I wasn't there, my lord, so I better find out.
No, but it's what he says in the judgment.
Yes.
That should have been done first.
Right, your lordship's right.
Because if you can re-amend the claim form, then you can particularise it.
I agree.
You can't particularise in the re-amended particulars of claim claims which aren't in the claim form.
Correct.
And as you pointed out, the claims in the re-amended particulars of claim, in most respects, are not to be found in the unamended claim form, but they are found in the amended claim form.
My lord, yes.
So isn't the question whether there was jurisdiction to amend the claim form?
Indeed.
And that doesn't seem to be an issue that's been argued anywhere.
No.
And not before the judge, not on your appeal, not in the respondent's notice. Nobody seems to address the question.
Well, my lord, I
Can the
think.
claim form be amended? Everybody's addressed the question.
Yes.
Can the re-amended particulars of claim be introduced?
Well, my lord, it's obviously our fault. We should have spotted, but we've effectively treated the principles that govern both as what's in issue.
But it's
Because
quite important to get the
very important.
technicalities right, because it's quite clear to me what the judge meant to do is what he did, which is strike out the pleading, but leave the claim form.
Yes.
Now, I would have thought that it logically follows that if you want to widen the claim and bring in a new claim, the first thing you have to do is amend the claim form,
Correct.
which you can do, provided you can get yourself within Rule 17.4.
Precisely.
And if you can amend the claim form, then you can particularise it.
You're also absolutely right. And
So what do we do with that? Because that seems to me to be the correct analysis, but it doesn't seem to me to be the issues that are being argued before us.
well, my lord, all the principles apply. All the principles of the interrelationship between Section 35. I mean, my learned friend and I part company on those. I just, with greatest possible respect, I cannot see how some of my learned friend's arguments about that can possibly be right. I mean, there can be no argument about the fact that Section 35 governs the ambit of Rule 17.4. And you simply can't say, as my learned friend does, that it's 17.4 that matters. I mean, that doesn't actually take us anywhere. And your lordship's point is absolutely right, that actually the proper focus should be on the amendment of the claim form, under which, so my lord, if I lose on the amendment of the claim form, I completely accept that, for the purpose of this argument, that the particular claim that they actually pleaded come under that claim. Your lordship's absolutely right.
The claim form is not a statement of case, is it?
My lord, no.
I think it is,
It is.
as defined in the rules.
Is it? All right.
Within the rules for that purpose, definitely is, in Part 16.
I think
Right.
if you
So
look in,
17.4 applies to both.
Yes.
if you look in CPR 2 point something, I think it defines a statement of case, including the claim form.
Yes.
Right.
And it must be, because it's entirely common, possible to amend a claim form at a stage where you haven't started to plead your particular claim. It
You're
happens
absolutely
every
right.
day of the week.
Exactly. And if that's done outside the limitation period,
Then it's vulnerable to an attack that is
Precisely.
not within 17.4.
and you then get a Deutsche Bahn, so we did it in the post office litigation, there were people joining later,
Yes.
and we had to say we were amending the claim form,
If you want to join a new
On-
party, you've got to amend the claim form.
precisely. And so those amendments, we had to agree, would not relate back.
So they date from as if you'd issued a
Exactly.
new claim form.
That's the Deutsche Bahn type,
Is that MasterCard?
but indeed,
Yes.
yeah, MasterCard and Deutsche Bahn. And so that's what you normally do. So you're also absolutely right. It turns on the difference between page 31 and page 93. If the judge had jurisdiction,
But this kind of brings me back to the point I was asking you about earlier, because, and correct me if I'm mischaracterising it, but I understood you to accept that there was no application before the judge to say that the claimants couldn't do what they were trying to do because they were outside the scope of the original claim form. In other words, there was no resistance to the application to amend the claim form on the basis that it took them outside the original scope of the claim form.
well, my lord, rightly or wrongly, the claim form and the new particular claim were treated together. And as Lord Justice Nugee's just pointed out, actually, the proper approach is to identify first whether the claim form can properly be amended. So your lordship's absolutely right. They didn't deal with them separately, and they should have done. And so I'm far from saying that the arguments were fully ventilated before the judge. I'm not saying that. But I thought, in fairness to Mr. Adkin below, taking the court to the place where my learned friend responded to his argument that there were no pleadings.
Yeah, but you see, it goes further than that, doesn't it? Because what one sees from the judge's judgment is that both sides argued the case before him on the basis of the particulars of claim. So both sides made a comparison between the re-amended particulars of claim and the re-amended particulars of claim. So both sides were looking at the particulars of claim for the basis of their argument as to whether the facts were substantially the same or not. And that's the way it was dealt with. And the conclusion of the judge was that the facts were substantially the same on the basis of that comparison, and that's a matter that can't be revived in this court.
my lord, that's how it was done. Your lordship's right. How it should have been done was to identify whether there were any facts in issue, given that the particulars of the claim had been struck out. And the point was taken. I was not ventilated as it's being ventilated now before the court. I completely accept that. But the point that there were no particular extant particular claim was taken, was responded to by my learned friend, and the judge had an opportunity to consider it and noted the difference in the wording between Section 35 and Rule 17. So it's absolutely right that the proper comparison should have been between 31 and 93, the original claim form and the new one. The new one's got nothing to do with the old one. So I completely take the point that my Lord Justice Nugee's point of how it should have been done, my Lord Justice Arnold's point that it wasn't done like that. That's correct. We would respectfully say that it is, in this situation, the right approach is to look only at the four corners of the claim form. Once in a situation where the particulars of the claim have been dismissed, there is in fact nothing to look at on the previous particulars of claim, because they've gone. And therefore, the right focus should be on the claim form itself, which is what we have said in the skeleton argument, and amending within the four corners of that claim form, which accords with what my learned friend submits, we should do is look at what the judge intended to do. The judge says, within that claim form. So it's all of a piece.
But I think you've accepted that in principle, if your amendment to the claim form satisfied section Rule 17.4, you can do it.
My lord, yes.
So
but if it doesn't, you can't.
But if it doesn't, you can't. But this is where we get into difficulties about what it is we're actually being asked to do, because we're not actually being asked to look at page 31, page 93, and decide how similar they are.
But
the judge doesn't seem to have done that. No. Nobody asked the judge to do that. Nobody's asking us to do it. And Lord Justice David Richardson says we can't do it. So what can we do? But
your lordship, your lordship doesn't need to look at 93, but the court does need to know that 93 is different. I put it in those terms.
Well, I have read it, and it's obviously different.
Yeah.
But the question is it substantially different? And that starts getting into a comparison. But we're not doing that.
But the point is, it's obviously substantially different on the face of it.
I see.
And so there's no real debate about that. And what we say is that it's wrong to cantilever.
I think Mr. Onslow would dispute that proposition. I think he would say, if he had to, although I don't think he says that this is a matter for us, but I'm sure he would say if he had to, that he would satisfy the 17.4 test on a comparison of the two claim forms.
Well, he may be able to say that, but...
and as my Lord Justice Nugee has just pointed out, it's not actually a question that's alive in this court.
My Lord, the question that is alive in this court is, did the learned judge below direct himself correctly by focusing on the particulars of claim?
Your point's a very simple one, is that if you take on board the words in issue, as are in issue, already in issue, it was wrong to look at the struck out particular
because they weren't
claim.
an issue.
And that's really the end of your... I mean, it's a 2-minute point.
It's a 2-minute point.
But the question is, what are the consequences? Where does that leave us? Because
well, once the court has identified... I mean, I thought this was trite. But
well, either you're right on that or you're wrong on that.
Precisely.
But if you're wrong on that, it's the end of the appeal. We don't have to worry. If you're right on it, I think we do have to worry about where it leaves us.
My Lord, yes. But the short point is that the jurisdiction of this court is first to identify whether the court below has misdirected itself. That's binary, as your Lordship says. And if the court below has misdirected itself, at that point, this court looks at what the correct approach is and applies it itself.
But that, if by applies it itself, you mean we start having to get into how similar or different page 93 is to page 31, that doesn't seem to me to be something that we are expected to get into, and consistent with what Lord Justice David Richards says, that it's open to us to get into. And certainly, speaking for myself, I'm reluctant to get into a comparative exercise of that sort.
But my lord, if the learned judge below misdirected himself, which is awesome. I mean, if he didn't, if he got it right, his approach was correct.
We don't have jurisdiction to look at it. Our jurisdiction is confined by the scope of the permission to appeal order.
Precisely. But
You have to read that with Lord Justice David Richards' subsequent directions as to what will be an issue in this appeal.
yes, and I think the learned friend, learned friend accepted, as I understood it. Oh, sorry, not learned friend, but when I've been given this morning a copy of the correspondence again. That the Lord Justice David Richards, I just find the.
It's his email, or email from the office, 23rd of October
23rd.
Yes.
at 9:56.
Yes. So there's no comparison to be done with the re-amended particulars of claim between the two lots of particulars of claim, but there's no bar to comparing the two claim forms, which is the right thing to do.
But he's refused permission on the question of whether the claim arises out of substantially the same facts. It's purely the jurisdictional issue.
But my lord, the point is this, that if the judge misdirected himself as to his jurisdiction by treating under section 35 facts already an issue, then that does engage this court's power to exercise the powers of the judge itself.
But that's not what Lord Justice David Richards has directed. He makes it perfectly clear that there are three questions, and if you win on each of the three questions, then the claim is dismissed. If you lose on any of the three questions, the order below stands. That's all we've got to decide, isn't it?
Well, he says at the end, yeah, he says either the re-amended particulars of claim stand in their entirety or struck out in their entirety. We completely agree about that.
The Court of Appeal will not be called upon to exercise any discretion or undertake any comparison of the re-amended particulars of claim with the re-amended particulars of claim, or remit the matter for further hearing below. I mean, either you win or you lose. I mean, that seems to be the effect of this direction.
Yes, we say that the judge didn't have any jurisdiction under section 35 to grant the permission to amend that he did grant,
Yeah.
because he wrongly thought facts were an issue which weren't.
Because the exercise he undertook was a comparison of the
Yes.
re-amended particulars of claim
Yes,
with the re-amended particulars of claim, and you say he wasn't able to do that.
yes.
Well, that's the first point that Lord Justice David Richards adverts to, and then there are 2 points taken in the Respondent's notice, which are alternative ways of upholding his judgment.
Yes, and one is variation, and one is a slip rule.
Yeah.
And both are miles too late and very, very prejudicial to the appellants, who thought that they were making an application to dispose of the whole proceedings, and as a result of some pretty extraordinary observations in the original judgment, it's hanging by a thread. So the idea that, I mean, if one looks at the authorities on the slip rule and variation, delay and prejudice are two key features that come up in those authorities. And a delay of 9 months was too long. I mean, I'll respond to what the learned friend says about this, but yeah, there was no application to the judge below on the slip rule. They actually tried to appeal his order, striking out the particular claim to this court, and that appeal was dismissed on permission. So they've made some procedural elections which militate very strongly against changing the goalposts one further time, when we've been through what most litigants would regard as the last chance saloon about 7 times. So there really is no proper basis on which either the power to vary under CPR 3.1 or the slip rule should militate in favour of this court changing the order the judge made.
Do you accept that we could do it if it was on a proper case?
Well, your lordships would have to exercise a discretion if you're going to. Apparently that's not going to happen. I mean, that might be an unhelpful response, my lord, but
I think that's unhelpful.
I withdraw it. I'm sorry. It was, I don't understand. But, I mean, there is an air of unreality. I mean, if there is, it is a discretion.
Well,
to
3.17 is passed in very general terms.
Indeed.
The slip rule is not. Are you taking a point that this wasn't a slip? That it's not within the scope of the rule?
Yeah, absolutely. It's not, it's not a slip. It's clearly not a slip. And B, even if it were, it would not be amenable to correction under the slip rule at this distance in time, because the cases on the slip rule make it clear that any application has to be made promptly. And an opportunistic application made because of the outcome of something else that you don't like is rarely entertained with any sympathy in the case of the slip rule. And my lords, I do respectfully submit that the fact that if we get to the question of exercising a discretion under the slip rule, I would respectfully invite the court just to look only for less than 5 minutes at one paragraph in the judge's original decision. It's paragraph 68, and it's on page 161. Of the core bundle. And this is a paragraph which my learned friend relies on very heavily in his submission that it would be in accordance with justice under the slip rule, under 3.17, and for the purposes of amendment. And so these are matters on which the judge has not been addressed, as we've seen from the transcript, and at a summary stage where the people whose integrity were being impugned were not there and had not given evidence. And what the judge later says in his later judgment, that he expressed some disquiet and drew attention to matters which appeared inconsistent and called for an explanation. And that's not what he did. He made findings. Here, paragraph 68, joint venture investment had been agreed with the LIA. Well, we've seen the letter which says it's agreed subject to contract. And the idea that business people think that something's agreed subject to contract has been agreed, but there isn't a contract yet. I mean, it's not a badge of dishonesty, and it's not untrue. Lawyers are the first people to point out to lay people there's a difference between agreement and a contract. Then Beeson Investments Limited, and that clearly meant Beeson Property Investments Limited, which was the company that owned the property. My learned friend's made a mistake about the name of the company in his own skeleton. People do make those mistakes. It's not a badge of dishonesty, and it wasn't untrue. See Lord Hoffman on How's Mary when you know that they're referring to your wife. in ICS and West Bromwich. I'm not sure I've got the name right. But... So that wasn't untrue either. And then following lengthy discussions and written advice, they'd been agreed at 21 million. Well, that was true. They'd said 50% for 10.5 million. And if you can multiply 10.5 by 2, you get to 21. And he beds it in at 69 with assertions and untruths. And then he talks about Mr. Laius being prepared to lie.
Where's Mrs. Greenwell's always getting us?
Well, my lord, if it's going to be said that because of the concerns expressed by the judge, and this, my learned friend does make this submission, it's a bit unfair for me not to be able to answer it.
All right. Yeah.
That the judge expressed disquiet and the interest of justice on the facts, as discussed by my learned friends, referred to these very paragraphs in his skeleton.
But it's been held that the re-amended particulars of claim establish claims with a real prospect of success. You've got no case to say that there should be summary judgment on the claims now advanced because they're fanciful.
Now, I'm not saying that. I'm just saying this court gets to the position where you're standing back applying the overriding objective the learned friends invited you to, and you're having regard to the paragraphs that he quotes. The suggestion, for example, at paragraph 81, that Mr. Laius, whose integrity is impugned in his absence, was prepared to lie. I mean, that does not even accord with what they say in their own pleading. And it doesn't accord. What Mr. Laius actually said was that Savills couldn't produce the summary and the valuation by the 23rd. And all the documents are only consistent with that. They could not produce the valuation by the 23rd. So all I'm saying, my lords, is those are matters which on their face, I can just show you where the emails are pleaded if necessary. On their face, they are extremely unfair. And if they're going to be prayed in aid to colour the court's view of how the discretion should be exercised or the interests of justice, I think, in my respectful submission, it's right the court should know they are, A, the judge wasn't addressed on them before he made the findings, and B, they're plainly wrong on their face.
Just
If
thinking
it's any
about
help,
your... Sorry.
We don't pray those in aid, and we haven't in either of our skeletons.
Just on your point about it being too late to operate the slip rule in particular, would it be fair to say this, that if the Section 35 point had been run with rather more enthusiasm before the judge, then this would have been, the precise terms of the order that he made would have been brought to the judge's attention at that stage, and that would have been rather less of a delay than asking us to correct the judgment for the first time.
Well, that's fair. That's
Yeah.
a fair observation.
So the need to correct the order really wouldn't have hit the claimants until this argument is fully ventilated, which you've accepted it wasn't.
My lord, no. But I mean, it was ventilated enough to be on notice of it.
Yes.
I mean, you just can't...
But it was rather, I mean, correct me if I'm wrong, it was rather being run as one of those points that's thrown in on the basis that somebody might be able to think of a way around it, rather than as the focus of the attack on the re-amendment.
Well, I think it might be a tiny bit unfair to Mr. Radcliffe, because he did pop it in as a skeleton a couple of times. And you know, the already an issue point a couple of times.
But he didn't make the suggestion that there's no jurisdiction because of the terms of Section 35. That's what my lord is putting.
Well, he didn't say it in those terms. It was right to fairly tell the court that on applying for permission. But I hope the court can see it's not quite as bleak as that.
No.
Because what he did say, and I've taken the court to where my learned friend responded to it, is he did say, look, there aren't any facts in issue. There aren't any facts already in issue because it's been struck out. And that's the very point the court is now wrestling. Because the pleadings have been struck out.
But you also say it's not a slip because the order reflects what the judge was intending to do.
Precisely.
So that's how you deal with, does that deal with both of the respondents' notice points?
Well, in anticipation of what my learned friend might say,
Yes,
I
I'm not saying you can't come back on that.
reply if I can. Could I just take the court to two brief authorities in relation to the court's general approach? I mentioned the worldwide point earlier, and this I respectfully submit should colour the court's approach to the variation point and or the slip rule. The first one is the worldwide decision, which is Authorities Bundle 1, tab 7. And it's at it's at 5 pages in. Sorry, they're not none. It's where it's the top of page 6, actually. And we say it's relevant by analogy, because what the court will effectively be doing is allowing a very, very late amendment. I mean, what is striking in this case is that they fought the strikeout without putting forward an alternative draft. And they did put forward an alternative draft during the strikeout. They didn't put forward the draft now advanced. So they're effectively having not just a late amendment, but one that's after they've lost. And 3 lines down, in the modern era, it's more readily recognised that in truth the payment of costs of an adjournment may well not adequately compensate someone who is desirous of being rid of a piece of litigation which has been hanging over his head for some time, and may not adequately compensate him for being totally, and we are afraid that there are no better words for it, mucked around at the last moment. Furthermore, the courts are now much more conscious that in assessing justice of a particular case, disruption caused to other litigants by last-minute adjournments, last-minute applications, have also to be brought in the scales. Well, there wasn't even a last-minute application to amend to the new format. What happened was the unamended one was struck out, and then you get the hanging by a thread, and we're all here. And Mr. King is a widower in his 80s, who is a man of good character, whose integrity has been impugned in these proceedings. It's little comfort that versions 1 to 5 have been struck out if these matters proceed. And in my respectful submission, those matters should properly weigh with the court in exercising the powers under either variation or slip rule provisions in accordance with the overriding objective. And that's actually picked up at Swain Mason in tab 29, just give them, it's tab 21 in the authorities bundle.
If the order fails to reflect the judge's intention, I mean, that's the requirement for the operation of the slip rule. Is there much discretion really involved? I mean, it's just wrong, isn't it, and has to be corrected?
Well, my lord, no.
Or is it not? It's not as clear-cut as that?
It's not as clear-cut as that in our respectful submission. And secondly, the slip rule is one that's to be applied promptly. Secondly, we would say that on the learned friend's analysis, if you look at the argument and what he said, what he said is what he's done. In fact, it didn't work.
That's the first point. I thought you were addressing this on discretion and not
Oh, I see.
not
You're
doing
saying,
it,
where
even if there is a mistake.
Yeah, my lord, I respectfully say that once the discretion, certainly a discretion under CPR on the variation provision, on any view, and the court has to exercise that in accordance with the overriding objective. And therefore, the relative situations of the parties, you've got a party on the other side to whom the normal pressures of costs and disapproval of costs are basically irrelevant. They've got £1 billion, we heard on security, something north of 800 million, I don't know what the actual figure is, sitting here, which because of sanctions, one of the few uses they can put it to is litigating against people here. And then you've got a family business on the other side with a widower in his 80s who they were going to get rid of the whole thing. And it's coming back by a slip rule 2 years later, or variation of an order. So, my lord, I mean, Swain Mason, I needn't take the court to it, but just so that the court's aware, Swain Mason at page 329 and 330, paragraphs 69 to 70, and it's pretty helpful because, I mean, maybe it is, may I briefly trespass on the court's goodwill and just show you those pages. So, 2749 in the report. As paragraph 69, as for Justice Lloyd, the appeal in worldwide was by the claimants against the refusal of Mr. Justice Moore-Pick in the Commercial Court to permit amendments to the claim in the first week or so of the trial. Amendments prompted not by discovery of some unsuspected evidence or fact, but by a reappraisal by newly instructed counsel of the merits of the case. Now, there wasn't a reappraisal prior to strikeout. An amendment to run a parallel case that might survive. It was said he felt the case previously pleaded would fail. Only by way of amendment could the case be put on an arguable basis. Well, Justice Waller gave the judgment of the court setting out the reasons why the appeal had been dismissed, and then he's quoted over the page at 2750. And then 5 lines down in the middle, in the modern era, it's more readily recognised. That's the passage I've already read out about being mucked about. And then at paragraph 70 on page 2750, later in the judgment, the court said this under the heading Approach to Last-Minute Amendments. Where a party has had many months to consider how he wants to put his case, and where it is not by virtue of some new factor appearing from some disclosure only recently made, why, one asks rhetorically, should he be entitled to cause the trial to be delayed, so far as his opponent is concerned, and why should he be entitled to cause inconvenience to other litigants? The only answer which can be given, and which counsel for Worldwide suggested applies in the incident case, is that without the amendment, serious injustice may be done because the new case is the only way the case can be argued. It raises a true issue between the parties, which justice requires to be decided. We accept that at the end of the day, balance has to be struck. Courts concerned doing justice, but justice to all litigants. Thus, where a last-minute amendment is sought with the consequences indicated. Everyone on the amending parties show the strength of the new case and why justice both to him and his opponent and other litigants requires him to be able to pursue it. And again, the heavy onus is reiterated at paragraph 72. Now, well, of course that's to do with amendment, and I'm not making the point on amendment. What I'm making the point on is the approach under the CPR to doing justice between the parties, having regard to all the circumstances. And that is mirrored in the approach to the slip rule in Tibbles, which is also in the bundle at tab 22, where prompt application and absence of prejudice are acknowledged as important.
You said it was to do with the slip rule, but I think you mean 3.17.
Well, my lord, funnily enough, it is it is about 3.17, but they make observations in relation to the slip rule
Oh, right.
as well. I mean, I accept their overtone, but I mean, in case it's helpful, it's at paragraph 53, Lord Justice Rick's back page of tab 22.
Little, if any, discussion.
Indeed. And then he makes observations which are to the court. I accept it was about the power to vary. But he says, he deals with the Earl of Inchcape case, which is the very high watermark of how it's ever been used, and is regarded usually as out of date and not necessarily right, and says that may be stretching the slip rule, as I venture to suggest above, in an appropriate case on prompt application, and in the absence of prejudice, it may well be the sort of case which CPR 3.17 would be available today, even though there's no misleading or misunderstanding. And then he refers to Bristol Myers Squibb. So,
Sorry, where's Bristol Myers and Squibb?
I'm so sorry, he doesn't refer to Bristol Myers Squibb, that's my learned friend. And I'll respond to the observations that are made about that in due course and hear how it's put. But the Tibbles at relevant paragraphs in Tibbles are paragraph 32, looking at Collier, and that's Lord Justice Buxton's judgment in Collier that's being cited at paragraph 32 in Tibbles. And there's the reference to rare examples. And what Lord Justice Buxton said in Collier and Williams is the basis of that jurisprudence is that jurisdiction under Rule 3.17 is not a substitute for an appeal. There must be additional material before the court in the form of evidence or possibly argument that would reserve the issue of whether the additional argument in itself is enough to attract jurisdiction. General thrust of Collier is that the case before the court before which Rule 3.17 is moved must be essentially different from one of simple error that could be righted on appeal. And it could have been righted on appeal, and they did it. The claimants did appeal the order made by the judge, but they didn't appeal that. And paragraph 39 of Tibbles, which is 2602, um, 3.1, the rule is, 39 has sub-paragraphs which helpfully set out relevant principles. Despite occasional references to a possible distinction between jurisdiction and discretion in the operation of CPR 3.17, there is in all probability no line to be drawn between the two. The rule is apparently broad and unfettered, but considerations of finality, the undesirability of allowing litigants to have two bites of the cherry, and the need to avoid undermining the concept of an appeal, all push towards a principled curtailment of an otherwise apparently open discretion. Whether that curtailment goes even further in the case of a final order does not arise in this appeal. But of course, it was a substantive disposition made on summary judgment as the basis of the strikeout of the particular claim. And then in subparagraph 2, 5 lines down, appropriately excised, namely normally only where there's been a material change, where the facts on which the original decision made were innocently or otherwise misstated. And then...
What about if the order made doesn't give effect to the underlying logic of the judge making the order?
Well, if the judge makes a mistake about what the order should be, that is not a slip rule, that's an appeal point. If the judge had said,
But can one use 31.7 in those circumstances? So the judge's logic leads to conclusion A. He nevertheless makes an order that says B. And it's clear that he intended to make order B, even though his own logic led to order A.
well, my lord,
Do you say that can only be remedied by an appeal?
well, there is arguably, on analysis, a tension between what he clearly intended to do and his own logic, because they might not be hermetically sealed and separate. And I think it is fair to look, if my learned friend's saying, look at what the judge intended, the judge says, based on that claim form. And that's a difficult point for my learned friend. If you invoke what the judge intended, what the judge said he was doing, if we're going to go down that route, what the judge said he was doing was giving them a chance to do it on that, frame the case within that claim form. And the court should not say, well, actually, because of what he later did, we're going to go back behind the order that's appealed to a previous judgment and change the underlying order there, even though it's perfectly clear that he did make an order which fixed them on our analysis with that claim form and that claim form alone. So, in our respectful submission, if you're going to give effect to the judge's intention, he intended to give them a chance to amend within the four corners of that claim form, and that's what he said. And it would not be fair or right to say otherwise. He expressly said that. Variation back to what he meant to do. If anyone should be applying for an application to vary, it should be me. Saying that if the judge's order that he made allows something that he clearly didn't intend to happen, it should be varied. Because he intended them to do it within the four corners of the claim form. So I'd like to vary it too. Get back to that. If that's.
But you don't have a ground of appeal on
Well,
that.
my lord, I don't. But all I'm saying is goose and the gander, hot kettle. I mean, I happen to be, in my respectful submission, in a strong position to say that the judge intended to do what he said he intended to do. And if you're going to apply CPR 3.17, you can't go completely off-piste and invent an intention which is outside the words of what the judge said. Or enlarge what he said he was going to do to accommodate what subsequently happened. The reference to that claim form is at Supplementary Bundle 188, page 5. I think it will.
No.
Unless I can assist the court further at this stage, those are my submissions.
Yes, Mr. Onslow.
Look, can I deal first with one or two of the points that have come up this morning? Plainly, I will want over the short adjournment to look more closely and remind myself of what Mr. Green has said this morning, and I will have more to say about these points as we proceed this afternoon. But perhaps the first point I should deal with is part of the question of what the judge actually intended, and the idea that it was intended that somehow, and I'm not, I have to say, entirely sure what this means, but any amendment of the claim, that any amendment should be within, as my friend was putting it a moment or two ago, within the four corners of the claim form. I'm not at all sure what that's meant, what was meant by that, and how we were supposed to give effect to it. But the starting point on this is to go to the judge's order at page 134 of the main bundle. Because the order explicitly provides, and I'm sure the court's got this already, the order explicitly provides and contemplates an amendment of the claim form. So the idea that this is paragraph 3.21 of the order. The idea that we are stuck in some way with the claim form, that everything we then put in with the existing claim form, and that everything we then put in our particulars of claim has got to fit precisely in some way. Not quite sure how that was going to be achieved, given the judge's fundamental conclusion that the claim as pleaded did not work. But the idea that somehow any amended particulars of claim should be somehow consistent, or within, as my friend puts it, the four corners of the claim form, it's an impossible submission, because it was plainly being contemplated by the judge, and one sees it in the order, that both the claim form and the particulars of claim were going to be amended. But there are further points here, which is as well to remind ourselves of at this stage. We are still, whether we're talking about the claim form or talking about the particulars of claim, we are still in the territory of 17.4. And clearly, if my friend is right about his construction of 17.4 and the effect that 35.5 is said to have on its meaning and application, then we're in 35.5 territory as well. But what it is critical to bear in mind in these circumstances, and it's dealt with in a number of the cases, and I can give your lordships the references after lunch, is the critical difference between a claim form and its required contents, and particulars of claim and their required contents. And if I could pick that up, please, by reference to part 16 of the CPR. It's a point that my Lord Justice Floyd touched on this morning. But if one turns to page 598 of the volume 1 of the 2020 White Paper, 16.2, subparagraph 1a, the claim form must contain a concise statement of the nature of the claim. And then if we turn, please, to 16.4, the contents of the particulars of claim. 16.41a, particulars of claim must include a concise statement of the facts on which the claimant relies. This is all covered in a case called Evans and a case called Travis Perkins, which, as I say, I can give your lordship's references to after the short adjournment. So they serve different functions and their contents are intended to be different, and indeed that's reflected in the standard form for a claim form that requires you only to state in a claim form the brief details of the claim.
Well, I take your point, but can I just see where this is going to? In your submission, is it ever possible to carry out the Section 35 and Rule 17.4 purely on the basis of the claim form?
No.
Because, yeah, so, and that's because you've got to look at facts, and you don't need facts in the claim form.
That's where I'm going.
Yeah.
That's where I'm going. And indeed, this is reflected. We have two skeletons before the court. Our second one was a point-by-point response to the claimant's replacement, the appellant's replacement a skeleton, in which we made precisely this point. And my Lord Justice Arnold, your lordship has the point that you can't stop, and it's impossible to at the claim form itself, because what 17.4 requires you to look at are the facts on which the claim form is based and the remedies sought and referred to in the claim form are applied for. And we perhaps should, at this point, so I can make that point good, look at specifically at Part 17, Rule 4, And the court will obviously appreciate that, subject to the difference in word, the are already in issue difference in wording, both Section 35 and CPR 17.4 require a comparison of the facts in the pre-existing pleading, the pre-amendment pleading, and for that matter the claim form, and the pleading in respect of which permission to amend is sought. And we see this spelt out for these purposes in 17.42. The court may allow an amendment whose effect will be to add or substitute, that's an important phrase, I'll come back to that, a new claim, but only if the new claim arises out of the same facts or substantially the same facts as a claim in respect of which the party applying for permission has already claimed a remedy in the proceedings. So the inquiry that the court must undertake when 17.4 is engaged, as we have always accepted it is engaged in the present case, the inquiry that the court must undertake is by reference to the facts in respect of which a remedy has been previously claimed. And both as a matter of practice and convention, and as a matter of the rules, and I've taken the court to 16.2 and 16.4, the place you look for the facts, pre-amendment and post-amendment, is the particulars of claim. And indeed, if one thinks about it, that's hardly surprising, because the document, the statement of case, the documents that the judge in the present case we submit correctly compared are particulars. They are particulars of the claim, the claims that appear in the claim form. And at the heart of what my friend has been saying to your lordships this morning seems to be a contention that somehow, because the particulars of claim, pre-existing particulars of claim, had been struck out, they ceased to exist. They were a nullity. They could simply be disregarded. A prime reason we submit why they could not have been, and should not now be disregarded, is the survival of the claim form. Because, pursuing the point that I was developing a moment or two ago, if you want to find what the facts were in respect of which a remedy had been previously claimed, you inevitably look, in our submission in any event, you inevitably look at the pre-existing particulars of claim. It's the only way you can do it.
Yeah, but we only get into this mess because of the failure to distinguish between summary judgment and striking out. If one looks at the judge's October 2018 judgment, as I was observing earlier, the reasoning is all in terms of no real prospect of success, that's to say the summary judgment test. And if as soon as one realises that what the judge was really doing was applying the summary judgment test on the claims then formulated, this whole difficulty disappears.
Well, and what I was going to refer your lordships to next on that very point is, although of course the order is framed in terms of a striking out, if one actually looks at 3.4, CPR 3.4 at page 84 in the 2020 White Book, Volume 1, page 84, it is right, of course, that an application, as it commonly is in this case, was made both under Part 24 and under Part 3, but 3.42 concerns only 3 categories of circumstance in which the court may strike out a statement of case. One is that the statement of case discloses no reasonable grounds for bringing or defending the claim. In other words, taking the facts pleaded as true is a legal claim disclosed. Well, that's not our case. Secondly, that the statement of case is an abuse of the court's process or is otherwise likely to obstruct the just disposal of the proceedings. That may or may not have been argued first time round, I don't know, but it wasn't the basis of the judge's decision. And thirdly, that there's been a failure to comply with a rule, practice, direction or court order, and that clearly wasn't the basis of the application, at any rate, as far as I'm aware. So that, I say at once, that this distinction between, it's perfectly obvious from our skeleton arguments, that this distinction between it having been a summary judgment exercise as opposed to a striking out exercise, although it's now plain, is not something that your lordships will readily recognise as featured in our thinking about this. And it perhaps should, well, in view of your lordship's interest in this point, it clearly should have done.
So is it your submission that the judge in October 2018 was wrong to strike out the fixed claim and should have granted summary judgment on his
Well, no,
conclusions?
no, Lord. What,
Because that, I think, would leave you in difficulties.
no, I'm not suggesting that at all.
No.
All I'm doing is following up the line of inquiry that the court has started on, which is that.
I understand that, but now the point's being raised. If just made, tend to suggest that you agree with our Lord Justice Arnold that this was really a summary judgment application, not a strikeout. But given that the judge did conclude there was no reasonable prospect of success on the claims then pleaded, the logical place one ends up is he should have granted summary judgment on all the claims, and the only
Except
possible
that he recognised that as
Yes.
against D7 to D2 to D7, it might be possible to extricate something.
That's precisely the point. What he in fact did was recognise that on the facts before the court, there was a claim against D2 to 7 which could be rescued.
might be. Yeah, I don't think you decided it could be.
Oh no, which might be well.
Might be possible
He
to
couldn't
find a
say
way
it could
through.
be. I couldn't say could be because he said it was hanging by a thread, and so he left that open to us. What he had decided, if one is looking at this through summary judgment eyes, what he had primarily decided is that applying a summary judgment test, if you like, to one issue in the case, which is whether or not King Sturge whether or not there was a real prospect of King Sturge being found to be dishonest.
Yes.
On that basis, because that, as the case was then pleaded, was the linchpin, if that's the right word, it was the basis of all the claims we were making against all the defendants. Having decided that issue, he was then able, and did dismiss the claim against the first defendant, and then we know what he did so far as the second to seventh defendants is concerned. But we also know, and this is very important, and my own friend referred to it this morning, we also know that he made no findings at all so far as the factual questions of the honesty, complicity, involvement in the fraud that we were alleging against the second to seventh defendants. He couldn't have done, he didn't do, and indeed the whole basis of the defendant's application to strike out or for summary judgment was to put all that to one side and say that's all very well, but their whole case as pleaded turns on the question of establishing King Sturge's complicity, King Sturge's dishonesty. So if one is pursuing, if you like, the summary judgment thread, what one sees is a decision, in fact, on one issue which fundamentally undermined, which destroyed the pleaded case, but the existing pleaded case against all defendants. But at the same time, as my Lord Justice Arnold has just pointed out, he recognised, because of his sense of disquiet, as he put it, he recognised that there is and was a pleadable case. That there might be a pleadable case against the other defendants if the claim were to be put differently. So what he did and what happened cannot be interpreted or construed as an exercise in which he granted summary judgment on the facts that he was leaving alive, if you like, for the purposes of an amendment, against the in favour of, I should say, the 2nd to 7th defendant. Can I add this at this stage, and indeed it's picked up, the idea that a pleading of the sort we're dealing with here becomes or could be treated as a nullity, or as if it never existed, cannot in our submission be right, because, as I said a moment or two ago, if you've got to consider the claim form and you've got to consider the amended claim form, which under the judge's order in October was envisaged, you cannot get away from looking at the pre-existing particulars of claim, whether struck out or not. That is the document that you inevitably end up looking at for the purposes of the exercise. And if that's right, and I take my Lord Justice Nugee's point this morning, well, if you treat the particulars of claim as if it didn't exist, well, it would follow that you may treat the defence as if it didn't exist. But if you can't do that, then you're plainly entitled to, and indeed again we would submit both 17.4 and 35.5 mandate the court to do this, you are plainly entitled to look at the defence. And just standing back then on that point, just for a moment, when one looks at the 17.4 test, which requires, well, one looks, if you like, primarily at 35.5, and whatever you may think that are already in issue means, and I'll come back to that phrase after the short adjournment, but whatever you may think it means, if you have got a pre-existing particulars of claim with a fully pleaded in 100 paragraphs plus defence, which sets out, which responds in detail and sets out a positive case the defendants have to the facts as pleaded in the particulars of claim, which I hardly need to remind the court has found are the same or substantially the same as the facts which we now plead. If you do have that material before the court, or the court considering an application to amend has that material, looking at the words already in issue, the first place you probably look, or entitled to look, is the defence if it exists at that point. In some cases it won't, because there will have been an application early on to strike out before a party has even served a defence. So again, we come back, whether one's applying 17.4 by its own lights on its own, or one is bringing in, and I will have something to say about this later, or one is bringing in 35.5 and saying, well...
We don't have any choice about that, do we?
Well, you don't have any choice. Don't have any choice in this sense, that I'd accept that 17.4, subject to a point that's raised in Good and Martin, the Human Rights Act point, which again I'll mention later, should be read consistently with the Act. And we say this in our skeleton at a number of points, that 17.4 can be read consistently with the Act without going down the route, my friend says, of ignoring the previous particulars of claim because it's been struck out.
Well, just leaving that point aside, I mean, coming back to the point my Lord Justice Floyd was just touching on, I mean, there's authority binding on this court, originating from Good and Martin and reaffirmed in Akers and Samba, that you have to read 17.4 as including the additional words already in issue that stem from 35.5.
Yes.
But on the other hand, I suppose you are entitled to preennate the fact that in Good and Martin, where this comes from, that was regarded not as further restricting 17.4, but rather as liberalising 17.4, but in order to give effect to the Human Rights Act.
2 points. One, that is certainly that is certainly right. The second is, to the extent it's relevant, and I may need to come back to this, and I want to think about it further over the lunch adjournment. The entire case ultimately depended on the Human Rights Act point. In other words, there comes a point in the judgment when it is noted, well, when, as I recall, the claimant's submission that as a matter of construction of 17.4 alone, you can bring into play, because this was the issue in the case, you can bring into play the alternative case that a defendant is running. That's not our situation. All I'm saying at this point is that a necessary resource for working out what facts were previously in issue and what facts are now in issue, regardless of the particulars of claim have formally been struck out, and assuming on that basis that the claim form, the action is continuing as the order expressly provided it should, subject to fulfilment of those contingencies. Once you accept that, then a prime place for looking to see whether facts are already in issue will not only be the pre-existing particulars of claim, if it exists, the defence.
I see the force of that in relation to whether the claim arises out of the facts, because that doesn't bring in the present tense. But when you add the words as or are already in issue, and you have the present tense to grapple with, that they are presumably at the time you're being asked to make the amendment.
Right. I come back in perhaps more slightly roundabout route to the claim form. If you've got a surviving claim form and you need to work out what facts in the surviving claim form or what facts on which the surviving claim form is based are in issue, then again we submit that you inevitably turn to the particulars of claim that lay behind and gave expression to the original claim form.
And then you find they've been struck out.
Well, you find they've been struck out, but the striking out is a procedural step.
Yeah.
None of this, we submit, could possibly prevent the court, and indeed it obviously wasn't the judge's intention, could possibly prevent the court when it wants to know what the facts previously in issue were by reference to the surviving claim form. Nothing prevents the court from looking at, indeed the court has to, because those are the particulars of the claim that was originally made. Nothing prevents the court from looking at the pre-existing particulars of the claim, notwithstanding that the procedural step of striking out or deciding issue, whether on a strikeout basis, or deciding issues which cause the collapse, if you like, of the claim as originally pleaded, have been the subject of a decision by the court. I'm going to move on to another topic, and now might be a convenient moment.
All right. How long are you planning to be this afternoon, subject to the usual caveats?
My lord, no more than an hour and a quarter.
Right. Well, we'll resume at 2 o'clock then.
All rise.